accomplish nothing else in this life other than to point out that judges who demand to be called Your Honor are social deviants who can get away with egregiously and maliciously harming you and ignoring your rights, then I've done something. Judge Ellen Tobin is a perfect example of this. You're going to see a video where she stomps on so many of the rights of the ADA. I don't know that I'm going to be able to list them all in this video, but I'm going to try. So let's get started.
That's okay.
My name's J.V. Shore. I'm a certified Americans with Disabilities Act advocate.
And your business address for the record, please?
Business address for the record, I'm not giving that.
Is there a reason is it confidential?
It is. I have PTSD, and there are mitigators that I have in place for that.
Okay. Good afternoon, everyone. As I said, I'm Judge Tobin. I have before me a letter dated December 12th, 2023, from J.V. Shore to the court regarding this case. It is a private and confidential case. It was addressed to the ADA coordinator for the Supreme Court of Nassau County, and my chambers is copied on this letter. I understand that you discussed this with Yvonne Marin, my principal law clerk, yesterday. The letter was forwarded to me, as you are made aware, by Paul Lamanna, email, Paul Lamanna being the ADA coordinator for the district. So I have before me the several requests in the letter. Today's conference is to address those requests. I'm going to give counsel a chance to be heard before I do that in just one moment. But because of the confidential nature of the information in the letter, the way that I'm going to proceed is I'm going to state the request in a general manner that does not betray confidential information, and I will state the court's response to each request, and I will go one by one in that way. Before I do that, I wanted to give each counsel, including Mr. Green, the attorney for the children, a chance to be heard if you would like. I'm starting with Ms. DeBiel, who is counsel for the party who submitted the request.
Your Honor, my client sent me a copy of the correspondence that was sent to the court. So at this time, the only thing I would add is that I'm asking this court to grant all of my client's requests for accommodations and all of her requests for compliance.
Okay, thank you, Ms. DeBiel. Ms. Chung?
Seeing that I have no understanding of what the accommodations are, I take no position, Your Honor.
Okay, thank you. And Mr. Green?
With respect to the accommodations, again, I have no idea what is being sought and what the basis of those are, and whether there are diagnoses or foundations upon which to grant or deny. So as I am in the dark, I can't take a position at the moment, although I can foresee that this will be an issue later down the road.
Okay, thank you. And counsel will raise any issues and seek any relief to the extent any counsel or party sees fit. So the first request for an accommodation is a request to have Mr. Shore serve as the defendant's ADA advocate. Yes, sir.
According to federal regulations under 28 CFR 35.160B2, this is supposed to be discussed in private, not in open court.
Sorry, Mr. Shore, please speak a little slower as our court reporter who is taking all of this down.
Okay.
She can't type that fast.
And if you could speak a little bit louder too, I'm having a hard time.
Okay. 28 CFR 35.160 B2. That requires that the court conduct accommodations with privacy and integrity, privacy and independence of the qualified individual with disabilities. This should not be discussed in open court.
What should not be discussed?
The accommodations and whether or not someone's going to have an objection to them from the other side. This is for equal access to court. This has nothing to do with subject matter or the legal matters of the court.
Well, as you're aware from Mr. Lamanna's email, certain of the requests are subject to rulings by this court, before whom the case is before. I have stated that in order to preserve the confidentiality, I am only going to say very general reference to what the request is, without any reference to any diagnoses or any other information. It is for the conduct of the case and these proceedings, which are in court. There are certain things that do need to be ruled on and disclosed. All court proceedings are public, of course. So certain of the requests, to the extent they affect proceedings in this case, are the subject of this conference and must be recorded by the court reporter, from which you will be able to order a transcript.
The day of and the day after this hearing, I wrote the judge's assistant and I wrote the ADA coordinator and asked how to get a copy of the transcript. There have been crickets. That was on the 15th. Been crickets ever since. So if someone needs the record immediately after a hearing to get their thoughts together about what just happened because they've been dissociated during the whole hearing, a transcript is not an effective accommodation. And this judge knows this, and all judges know this. And so I'm going to keep pushing this. This is BS.
Your Honor, if I may, Your Honor, just interject for just a moment.
Sure.
I know the court, when it sends out the notices for these proceedings, there is usually a warning attached that the proceedings are not permitted to be recorded in any other method other than by the court reporter. I just figured now would be an appropriate time, since we're talking about these kinds of issues, that the court restate the court's position with respect to that, because I understand that there was colloquy about that, colloquy about that the other day.
Yes,
you're welcome.
That was the first issue that the court wanted to address. There is absolutely no electronic recording of this proceeding by any party or any attendee to this proceeding or any other proceedings before the court. Any violations of the court rule will result in sanctions or other penalties. Okay, so I'm going to take the requests one by one. The first request for accommodation, as stated, is a request to have Mr. Shore serve as defendant's advocate. That request is granted to the extent defendant is permitted to have Mr. Shore, who is referred to as an ADA advocate, present at court proceedings conducted virtually via Microsoft Teams or held in person. This does not preclude the court from conducting in-person hearings as may be necessary and proper for the administration of justice. Request number 2 is a request for a complete copy of defendant's case file and the contents therein. That request is granted in part and denied in part. Defendant is represented by counsel in this case, Ms. DeBeal. Defendant may obtain any written records in this case from her counsel. All defendant also has access to the New York State electronic case file system, or what we refer to as NYSIF. All records are on NYSIF and may be accessed by defendant or her attorney. The defendant's attorney will provide defendant with future court dates via email or other writing. However, communications between defendant and her attorney are private and confidential. Request number 3 is a request for defendant to be served by mail with hard copies of documents. Request number 3 is denied. Defendant is represented by counsel and has consented to service of legal documents in this action through the NYSIF system. All documents may be accessed by defendant or defendant's attorney. Request number 4 is a request for defendant to attend court by online platform or telephonically. Request number 4 is granted to the extent the court will proceed with conferences via Microsoft Teams when the appearance of the litigants is required, but sworn testimony is not required, and it is further appropriate to do so. Request number 5 is a request for communication access real-time translation, or CART, and transcripts. Request number 5 is denied. The proceedings in this case will be conducted the proceedings in this case that involve the parties will be conducted in the presence of an official court reporter. Defendant will have the opportunity to order a transcript at defendant's expense at the conclusion of each proceeding. Request number 6 is a request to allow defendant to record the legal proceedings. Request number 6 is denied. As explained, court rules prohibit any recording of the proceedings with the court, and all proceedings will be recorded by the official court reporter. Request number 7, it requests that defendant not be required to wait for long periods of time. Request number 7 is denied. Request number 8 is a request for defendant to take breaks. The request is granted to the extent defendant is permitted to request reasonable breaks during proceedings. The court will permit breaks as reasonable and appropriate under the circumstances to ensure minimal disruption to the proceedings. Request number 9 is a request regarding the use of plain English and slow speech. The request is denied. Defendant may ask for clarification or repetition of statements as needed. Request number 10 is a request for definitions. Request number 10 is denied. The defendant may consult with her attorney or advocate as needed. Request number 11 is a request for extended deadlines. Request number 11 is granted to the extent the court will provide for reasonable and appropriate deadlines on a case-by-case basis. Request number 12 is a request regarding contact with the plaintiff. Request number 12 is denied. Requests 13 and 14 are requests to allow defendant's ADA advocate to immediately interject into proceedings regarding misinformation or disability needs. Requests number 13 and 14 are denied. The ADA advocate may not participate in the court proceedings or interrupt the proceedings in any manner. A failure to comply with this directive will result in the removal of the ADA advocate from the proceedings. Defendant may confer with the ADA advocate during the proceedings. The ADA advocate is not an attorney and will not be permitted to serve as defendant's legal counsel. Request number 15 is a request to permit ADA advocate to record all court proceedings. Request number 15 is denied. As discussed, electronic recording of the court proceedings is prohibited. Any violations of this rule may result in ejectment, sanctions, or other penalties. Request number 16 is a request for an ex parte hearing regarding ADA access if needed. Request number 16 is referred to the administrator or ADA coordinator for the Supreme Court of Nassau County. And that is a completion of the court's rulings on the requests that were received by defendant.
So there's several things that I'm going to bring out here. I'm not going to be able to cover all of the violations here, but Ellen brings the discussion of the accommodations even generally into the public court forum. Well, let me tell you, when you're asking for accommodations and it's discussed in front of your opposing party, we shall say, your adversary, that's intimidating. It's threatening. It interferes with your ability to get equal access because it's embarrassing to the litigant. It also violates federal law 28 CFR 35.160b2 that says that the court must provide privacy. Ellen also allows the opposing parties in the GAL, the guardian ad litem, to speak to the accommodations requests, and the guardian ad litem, Mark Green, to make comments that were intimidating. Quote, "I can foresee that this will be an issue down the road," end quote. I mean, that's nothing but intimidation. And statements that revealed that he had prior knowledge of the discussion of recording as an accommodation, which means someone leaked this information to him, and he chose to use it in an intimidating and discriminating way when he had absolutely no business commenting to my client's accommodation needs. Ellen also issues denials of her accommodation requests, of the accommodation requests we put in, without any ADA reason. There are 4 reasons for a denial to be issued. She didn't give any of them. So she just said no. So that's not equal access, and it's not in compliance with the ADA. And many of these were easily achievable, readily achievable accommodations. CART, for instance. Ellen said that the accommodations could affect proceedings. Well, CART doesn't affect the proceedings, but what it does affect is someone with a communication disability. CART offers them the ability to see a full page of the transcript at a time, and they can scroll back up and see what was said prior. That keeps them from having to take notes, split their mental energy, lose focus, lose their executive function. When someone with PTSD or communication disabilities has stress, further aggravating stressors on them, then they need to have mitigators, and this court's not offering that. This is what Ellen Tobin thinks is justice, and she has absolutely no training in how the ADA is to be administered. I want this on every social media you can find to put on. If you'll share this, I would appreciate it, and I would like that. Thank you.